Hello everyone, my name is Marie. I am a marriage and family therapist in the state of Washington. I'm currently studying to get my PhD in marriage and family therapy, and as a result I was asked to create a video to talk about the role of a therapist, specifically a marriage and family therapist, in divorce proceedings. So we'll cover the order of events, how the process of divorce works. We'll talk about how child custody is involved and what that kind of entails. We will also talk about evaluating mental health of parents, the ethics according to the American Association for Marriage and Family Therapists. We will talk about some tips if you are subpoenaed. So let's talk about the divorce process itself. I will be addressing the divorce process in the state of Washington, but the divorce process around the United States is pretty similar. Different timelines might differ state to state or county to county even. So the first process is to file the dissolution of marriage. This is the paperwork that initiates the divorce process and is typically done by one member of the couple, but can be done by both. And Washington is a no-fault divorce state, meaning that the couple does not have to prove wrongdoing in order to obtain a divorce. They just have to prove that their marriage is beyond repair. Second, the other spouse, or the person would be called the respondent in the legal terms. The respondent has 20 days to respond. If they do not respond within 20 days, unless they are a member of an active duty military member, the petitioner, the person who filed the petition, essentially is granted a divorce and everything that they asked for. However, if the respondent responds in the 20 days, then then the divorce process continues as normal. In situations or circumstances where the petitioner cannot locate to serve the paperwork, the serving must be done by somebody over the age of 18 and can be done by a sheriff if necessary. So if the respondent is not able to be located, there are lots of rules and regulations as to what happens next, but some of the options, if the circumstances fit, would be to send a certified mail copy of the petition or to publish it in the newspaper for 5 days. If the person does not respond in the 20 days after that, then the divorce would be ended and the petitioner would get what they want. The next piece is temporary orders. So the respondent responded, and now there's temporary orders that are discussed. These are temporary child custody agreements, temporary child support agreements, temporary agreements that of who lives in the home, temporary agreements that none of the property or like stocks and bonds would be sold or given away, so that none of that affects the divorce process. The next piece is the parent education seminar. So parents in every county in Washington except for one are required to take a parent education class. This education class is designed to be conducted by local marriage and family therapists typically, but can be done by any therapist, to explain the effect that a divorce has on children and kind of give them some tips and tricks to co-parent successfully. It will also give them some education about the child custody agreement process and how that works, which can help parents feel a lot better about it. Second is the discovery process. The discovery process is where all documentation, all information is obtained. Any kind of evaluations done by therapists or other mental health professionals would be done during this stage, and we'll talk about those more specifically later in the video. So the first thing that might be required is physical documentation. That might be physical documentation of insurance, physical documentation of your pay, of your income of various sorts. They may require each party to answer questions in writing, and releases of information may be obtained for bank information, medical records, or employer information. Requests for admission statement. Each spouse can request that the partner answer questions written by them to like admit or deny certain accusations that are being made. And these are all under oath. So depositions and examinations are given to parties and important witnesses like family, friends, coworkers, lots of different things, medical professionals, to gather relevant information. And once all of this relevant information is gathered, you have kind of amassed the information of things that need to be kind of divvied up between the two people and the state of mind of both people. Now you can move on to mediation. And mediation is required in the state of Washington for everybody to at least attempt. However, some go beyond this stage. So mediation is where each party, their lawyers, and a neutral third party work to try to agree on what happens with all the stuff and with the kids, if there are children present, and the neutral third party kind of leads the conversation and tries to mediate the conversation to be productive, and lots of people are able to complete this step and agree finally on something, and this lowers the cost for families and keeps them out of trial, which can be expensive and very long. So if they're able to reach an agreement on what happens with all this stuff and with all the children and all of that, each party will sign the agreement, and then it gets sent off to be finalized. And if they can agree on most of it, generally, then they would move to trial. If they do not agree on anything, or there are some things left, like a parenting plan would be one example. And then the trial process is presided over by a judge. Things are decided by the judge, not a jury, because it's a civil matter. And the petitioner's lawyer will first start and give their side of the case, provide witnesses, expert testimony and evidence, and then the respondent would also, their lawyer would do the same thing. Then the judge would make decisions and finalize the divorce for them, which is why mediation is kind of the preferred plan, because then people have more control over what happens. And so after the judge signs, or each member signs after a mediation, it gets sent to the county clerk's office. It sits there for 90 days, and after 90 days, if there are no changes and no new information, then the divorce is finalized. So now let's talk about child custody issues. The state of Washington requires all divorces that include children to be evaluated by a mental health professional, marriage and family therapist, a social worker, or a psychologist. So this person will talk to the parents, they will talk to the children, they will observe each child and the parent interact with each other, but they will also interview teachers, babysitters, nannies, daycare staff, their doctor. If the child already has a therapist, they will also talk with that therapist. They will likely look at each home that the parent is living in, the child's space in the home, and make observations. Those observations must be, and we'll talk about this in the ethics portion of the video, must be grounded in science. like concrete observations and not opinion, because giving opinion about who is better is unethical for a therapist to do. The judge then reads the report from that therapist and uses that information pretty heavily. However, they do not have to listen to that information. If the judge sees another red flag that the therapist didn't note, the judge may not listen to what the therapist's recommendations are. What the paper that people walk out with when it comes to children is called the parenting plan in the state of Washington. And so the parenting plan entails, first and foremost, when the child is at mom's, when the child is at dad's, or whatever their parent kind of situation is, which parent has them during the weekdays, which one has them the weekends, which one and holidays, birthdays, vacation, telephone access, and relocation rules for parents. So how far can a parent move? How much notice does the other parent have to be given? That kind of stuff. But not only that, those are kind of the basics. Parenting plans can also include discipline rules, can include whether or not the parent has overnight guests, can include clauses about not saying negative things about the other parent in front of the child. One exception to the parenting plan is when there is an instance of domestic violence or child abuse by one parent that is founded and has been investigated and shown to be a real threat. Those parenting plans can include not having visitation, first and foremost, or having supervised visitation in a visitation center, which happens sometimes in the state. It can also, if there's domestic violence but no danger to the child, include dropping and picking the child up at a public place like the police station, or being done by a third party that's kind of impartial. And so those are some of the things that are involved in the parenting plan. Let's talk about mental health evaluations for parents. Sometimes when a parent is struggling with mental health or substance abuse issues, and that's one of the reasons for the divorce, a therapist may be asked to provide an evaluation on the parents. Typically, the evaluation would not cause the parent to lose visitation or rights. However, it may pause those rights to visitation while the parent gets therapy, medication management, or rehab as seen fit and is shown to have improvement and be a safe parent for that child to be around. Again, all recommendations by the therapist must have a scientific basis and be very concrete. All assessment tools must be very valid and have proof of validation and all of those things to be making recommendations like that. So let's talk about ethics in divorce and being involved in divorce cases as a marriage and family therapist. The American Association for Marriage and Family Therapy have a whole section 7, related to involvement in criminal and divorce proceedings as a therapist. And so let's talk about some of the really important rules that a therapist must abide by in order to be ethical, and that's very important. So the first one is Rule 7.2. This is the rule, and I've mentioned it already, that the therapist has to be objective, fair, and cannot make misleading judgments. Everything must be based on fact and on scientific evidence when they're speaking in court or making reports or recommendations. The next rule is that the therapist must obtain informed consent from all parties involved, but that's not strange for therapy. The added caveat to this rule when it comes to evaluations is that there has to be an added education about the evaluation process, how recommendations might be used, financial arrangements, and the role of the therapist. Because as we'll see right now, the therapist cannot be the family or the child's actual therapist. They have to have a separate role as an evaluator for the court. Otherwise, it's seen as a kind of dual relationship. It's not ethical. Marriage and family therapists must understand all laws, judgments, rules, and regulations that are kind of related to divorce in their area. They must know what they're supposed to, what's expected of them, what's expected of divorce proceedings. They have to be very knowledgeable about the subject before they enter into evaluating for the court. Let's talk about some tips in case you are subpoenaed by the court. Any therapist can be subpoenaed by the court in a divorce proceeding if they're seeing the children or one of the spouses. And so it's very important to first make sure that the subpoena is valid. If you break confidentiality and the subpoena is not valid, you could get into trouble for breaking confidentiality when it wasn't necessary. And so subpoena is delivered either in person or via certified mail. The court, you have to make sure that the court has jurisdiction over you as a professional. Out-of-state courts or even out-of-county courts may not have jurisdiction, and so consulting a lawyer of your own may be a very good step in this process. And if it is valid, then the mental health professional or the marriage and family therapist should respond to comply or oppose the subpoena as soon as possible. And you can oppose the subpoena in part or in full, and we'll talk a little bit more about that in just a second. So you have to first contact the client. Next thing, you would contact the client. You would explain the situation and kind of talk about what kind of information could or couldn't be shared, what kind of questions may be asked, or why they're requesting this information, and request the release of information from the client. The client may sign it, and then you can go to court or fill out whatever paperwork, send their file at that point. However, if the client doesn't want you to share this information, or for whatever reason, then the therapist can obtain their own counsel and have them negotiate eliminating certain parts of the information or eliminating the therapist's role in this court case as a whole. If negotiations and can't be reached and people cannot agree on not including the therapist in and their information in this process, there's a couple options to request from the judge. First, the court can seal all information so that only the necessary people need to know. It's not a matter of public record. The court can also limit disclosure to specific areas that are important. Another option is to discuss the information in chambers with only the judge so that nobody outside of the judge who's making the decision hears the information. And then there is also a federal rule called the Federal Rule of Civil Court Procedure 45C that says that a therapist can deny the demand if they can prove a significant burden on the therapist. Also, kind of another little loophole is that the notes, if they're stored separately from the medical record, do not have to be shared because they're not part of the medical record. So the last step is to determine whether or not you should testify. The therapist does not have to answer questions that are privacy protected. However, if the therapist is found to use this as an excuse an unreasonable amount of times, they may get fined or held in contempt of court. So it's important that the therapist hire their own representation. So I'd really like to thank everybody for watching this video. I will put the resources that I have, the references, down in the bottom under the video so that if you have any questions or want to read more about it, you can read the references that I have used as information for this video. So thank you, and hopefully it was informative.